So this is a legal, a moral, and ethical, and a financial incentives for the city to do the right thing, and for the county to do the right thing.
Well, it is, because really the violations of the law that we discovered, the banks and the mortgage servicing companies and the trustees they hire to record these documents are essentially breaking the law, violating that statute. And in our small little study of just 193 properties, we identified about $4.1 million in fines.
Let's bump back a second about, the risks. And, as Multnomah County, we have in-house counsel with expertise in any number of areas: constitutional law, civil torts, finance, budget law, matters associated with county concern. But we're not subject matter experts on banking or on these, these very large issues, which are sort of new and innovative areas of law. And so one of the risks associated was actually having the resources to stand up one small little county in Oregon against these big banks.
Just how many of these makeshift homes could be eliminated with $9 million? How many homeless school children can you cover or feed with $9 million? Now, you are about to witness an exercise in modern Heglian dialect, pitting that which is good, the lawsuits and movements in Multnomah County, against that which is evil, the breach of social contract in Seattle and King County, in which they spurn the expert witness testimony of their own hired consultant, who reached the exact same result as the Multnomah Commissioners, who settled with MERS for $9 million last week. Not to mention her successful testimony in Wolf versus Wells Fargo, a $5.5 million jury fraud verdict in favor of the homeowners the month prior. Now, bless his heart, City Councilor Nick Licata has fought the good fight often, but he was rebuffed by people who are afraid of the truth. And that person, or those people, apparently includes Attorney General Bob Ferguson. Now, as a former Assistant Attorney General, I eagerly await Ferguson's response to Nick Licata's inquiry about the lawfulness of MERS. Okay? Now, will he do the good thing and align himself with Multnomah, or will he instead line his pockets with MERS money? Now, I have to get back to work. My work largely involves helping homeowners, and it is shameful that people like me have to take time out of our days to make our government less malfeasant, okay? But that is precisely what we're going to do. We will grab them by the proverbial collar and scruff of the neck and philosophically beat them about the head and thorax until they do the right thing. Now, who among them wish to be held accountable for failure to act at this point? That's the question. Stay tuned for the answer.
We need to basically recognize that what the banks are doing to citizens like Jane here is really criminal activity.
You got that right.
It's not only myself facing this kind of a situation,
right,
and there are millions of people are in the same position.
Unless we as activists take things in our own hands, it's not going to change. And what's happening elsewhere, things that are worse in other cities, are going to happen in Seattle.
No one wanted me to bring Maria. No, I still wanted to bring her.
Right, and by the way, I applaud you for doing that. What they can read is that jury verdict right here online. Did the defendant present or use a document with knowledge that the document was a fraudulent lien or claim against real property or interest in real property with an intent to cause financial injury or mental anguish and emotional distress? Yes. And so she is allowed to talk about every bit of that. She could come before us and say the same things that she told that jury, and then she could say, and the finding of law by a trier of fact was blank. And she can do that every day, brother. Come on. You know I'm right.
And I saw that one of the three features of the settlement is that it is a legal precedent. I say, I can say, yes, I'm pleased with the terms of the settlement. And so since it's a precedent, we want our courts to be able to use it, because I went to law school and I understand that that's what a precedent is.
Okay. Madam Chair, I have a question. And so we're in a public meeting.
Yes.
If we have newspapers, reporters here, and they report on what they hear in this forum, they can put it in a story. And if other counties within Oregon decide to do that, we're not breaking any of the public records rules, are we?
No, Commissioner. The settlement agreement specifically says that we can discuss this in public meetings, and this is our whole public meetings law is to allow transparency within government. So this can be reported on. Everything that we say may be quoted in newspapers or other publications.
R5, authorizing settlement of County of Multnomah versus Mortgage Electronic Registration System Incorporated et al., Multnomah County Circuit Court case number 12-16328.
We have a little PowerPoint here today, and we're going to be going through that. That's really just to help aid our discussion, and we hope this is a discussion. We're here to answer any questions you have and to provide some clarity around the litigation and why we were involved. So, as an overview, we're going to start with introductions. We're going to explain what MERS is. We'll give you a background of the litigation. We'll give you a background of the resolution, explain why it matters, and then we'll take questions. We're going to start sort of at the beginning, explaining what MERS is. And to do that, I'm going to pass it over to Tom.
Thank you. And I want to reiterate what was said, that the county employees were wonderful to work with. We could have never brought a case like this unless we had complete cooperation. And we took a lot of hours away from their normal jobs to do something unusual. So I want to thank them. So what is this lawsuit, or what was this lawsuit about? This was the county suing MERS and a consortium of virtually every big bank and a lot of small banks in this country. MERS was created by the banks as a repository back in 1997. So instead of what we normally hear, that we've got to break up the big banks, these banks actually all got together to work together to create a system where they would be able to attempt to get around filing with the counties. And this was a nationwide plan by them to get around filing with the counties. And in addition to lost filing fees that the county suffered, the county record was also contaminated, because no longer were the beneficiaries of deeds of trust being listed so that people would actually know who the beneficiary of the deed of trust was or who the bank was. MERS was instead listed. And the reason that the banks wanted to do this was they wanted to quickly turn over these mortgages, make money on these mortgages, and quickly interchange them between the banks. And normally when the mortgages are turned over, you have to go to the county recorder's office if you want to preserve your security interests.
So that's helpful, because I would think that since there are over 3,000 counties in the country, and since MERS has a much more networked communications system, even than the counties, although our network is getting better, that being able to confer with our network in order to protect people and from this kind of foreclosure activity, and from the kind of ripping off of counties over recording fees, that might be helpful. And I trust that there's still some opportunity for other counties to pursue this kind of litigation. I'm getting a head nod.
I believe there is, Commissioner. And for people who are interested in learning more about the legal arguments, these cases were briefed extensively before the state and federal courts, and those are also public records.
MERS is utilized as a means of obfuscating the actual ownership with a beneficial interest in the notes and deeds of trust of citizens all over this city.
The borrower needs to know who they're supposed to be negotiating with. You all right? The note has to go first, and the deed of trust is simply incident to that transfer. If you just get transferred the deed of trust, you got nothing.
Went on down to the courthouse yesterday. I can't believe what I saw.
They've totally obfuscated who actually owns what, depriving Ms. Pardo of her ability to actually negotiate with the note holder and come to some agreement.
Originally, the note holder was
The
Land home.
Land home, right?
Yes, ma'am.
Okay. And then land home assigned it allegedly to who?
We have no idea.
Oh.
That's the problem. That's why we're here to get discovery, to figure out what happened.
When I was a civil rights and employment trial attorney in the 1990s, I thought I knew what corruption and abuse were. Now, that experience in no ways prepared me for what I would see after I was an escrow attorney some years later. Now, keep in mind that all of this is cyclical. Remember the Keating Five and the S&L crisis of the 1980s, Enron in the 1990s, and now this. All of it to disfranchise the middle class.
No, they need to come down. They are not serving humanity.
Great day to make this council. The money for the teachers is right here in Marie McDonald's forensic report and examination.
And if we could just have Ms. McDonald present her findings so that the public doesn't feel that, again, things are being hidden from them, that, again, people are being bought and paid for by the banks.
It has to happen. You owe it to us to do it. And that's it. So who's going to contact me today before I leave?
Thank you, Mr. King.
Now, I got 5 seconds. Anyone?
Of the 10 signatures that are on my home loan, there's only one legal signature, mine. One of them turns out to be the name of a porn star, Autumn Bourne.